Good evening. My name is Thomas Rydell. I'm a district court judge in the 7th Judicial District of Iowa. That district includes the counties of Cedar, Clinton, Jackson, Muscatine, and Scott. It is my pleasure to welcome all of you here to this special session of the Iowa Supreme Court. These special sessions offer Iowans an opportunity to observe Supreme Court proceedings firsthand. Later tonight, after the court adjourns, everyone is invited to attend a public reception in the Big M Commons. The reception has been catered by the Muscatine Community College Culinary Arts Career Academy. It's going to include fruit trays, cookies, and water. The justices will all be at this reception. They're eager to visit with all of you, so please feel free to strike up a conversation with them. You need to know, however, that judicial ethics prohibit the justices from speaking about pending cases, so they cannot discuss the case that they will hear tonight with you. The justices can speak in general terms about court procedures, the role of the courts, and other topics. This unique opportunity to meet with the justices has been sponsored by the Muscatine County Bar Association. Now, before I explain the work and role of the Supreme Court and the process we are about to observe, I want to thank some people who helped with the arrangements for this event. First and foremost, thanks to the Muscatine High School principal, Terry Hoganson, for allowing the court to use this wonderful auditorium. And thanks to his staff members, Jeff Hyde, Jeff Miller, Doreen Bourday, and Lori Dusenberry for stage setup, sound, lighting, and for coordinating the visit. The court also thanks the Muscatine County Bar Association and Bar Association members Alan Ostergen, Brandy Olson, Will Mathis, Cale Nicely, and Esther Dean for planning the event and sponsoring the reception. Additionally, the court thanks Sheriff Ryan and the Muscatine County Sheriff's Department and Chief Brett Talkington and the Muscatine Police Department for providing security. Now I will briefly discuss how the Supreme Court works and the process we are about to observe. Most of you have probably seen a trial either in person, real life, or portrayed in either a movie or a TV show. Maybe some of you have even served as jurors. I think I recognize a few of you from that role. What happens, though, after a trial? That's kind of a question. When a party is unhappy with the result at trial, the party may appeal the case to a higher court called an appellate court. An appeal is a higher court's review of a lower court's decision or judgment. That is done to assure the substantial justice has been rendered. The right of appeal is a fundamental element of procedural fairness as generally understood in this country. Now, the appeal process is very different from a trial in the trial court. In the trial court, one judge presides over the case and makes decisions. In an appellate court, a group of judges are collectively responsible for making a decision. The basic concept of an appeal is that difficult legal questions are decided by a group of judges rather than merely submitting the opinion, substituting the opinion of one appellate judge for that of one trial court judge. Tonight, you will see an oral argument. Oral argument is an opportunity for the attorneys to emphasize certain legal principles and for the Supreme Court to ask the attorneys questions about the case to help clarify the parties' legal arguments. Do not be surprised if the justices interrupt a lawyer's argument to ask questions. Time is limited, and the justices may want to focus the argument on particular issues in the case. Now, before the court begins, I want to mention some rules of decorum. During the proceedings, please be sure to turn off all electronics, to be quiet and respectful of others. And by electronics, that does include your cell phones, please. If you must leave the auditorium, please do so quietly. You can find more information on the Iowa Supreme Court, the appeals process, and a summary of tonight's case in your program. Thank you, and please enjoy this unique opportunity to see the Iowa Supreme Court in session.
Everyone, please be seated. And welcome to this special session of the Iowa Supreme Court held at Muscatine High School. We are very pleased to be in your community this evening. We have one case that will be submitted. That case is State of Iowa versus Lamar Wilson. Ms. Nye, you may proceed with your argument.
May it please the court. My name is Melinda Nye with the Appellate Defender's Office.
Could you pull the microphone a little closer? Thank you.
In 2017, the Iowa Legislature enacted House File 517, which expanded and clarified the rights of lawful gun owners in Iowa. Particularly at issue in this case is amendments to Chapter 704 regarding justification defenses in criminal proceedings. About 2 months after the bill went into effect, Lamar Wilson was with friends on the pedestrian mall in Iowa City. A group of about 6 or 7 people from Cedar Rapids, with whom there was a longstanding animosity, came to the pedestrian mall, and there was an interaction, a confrontation, words were exchanged, and ultimately shots were fired. Lamar Wilson was lawfully possessing a weapon that evening, and he shot 5 times, wounding 3 people, hitting 3 people, wounding 2, and killing Khalid Jones. Wilson was charged with first-degree murder, 1 count of first-degree murder, 2 counts of attempted murder, and intimidation. He sought, before trial, he sought to have a pretrial hearing on the applicability of Chapter 704.13, which is included in these amendments in House File 517. He sought pretrial immunity from prosecution for in the case, and the district court ultimately decided not to denied the motion to dismiss and denied the right to a pretrial hearing in which Wilson could establish his immunity pursuant to the statute, and decided instead that it would hear the evidence at trial and make a ruling on the immunity question after trial.
If it is pretrial or prosecutorial immunity, shouldn't the court rule on that at the time a charge would be brought?
I don't think so. I don't think that. I mean, it could be possible, but when you're that far pre-trial, when you've got trial information in minutes or a criminal complaint, often the defendant is the person who has the facts, who's in control of the evidence and the facts, and knows the surrounding circumstances that would support a justification.
Well, then the defendant would have to suffer through a prosecution before it would be determined that they'd be immune from it. What sense would that make? Maybe I misunderstood. I thought you meant sort of when charges were initially filed. I think there's immunity requires a pre-trial, like before trial. There has to be some legal proceedings to get the ball rolling before, but upon a motion to dismiss by the defendant should be entitled to a pre-trial hearing, an evidentiary hearing, in which the defendant establishes or attempts to establish his immunity from prosecution.
You know, all that may be, but looking at the text of the statute, and I'm going to read part of it to you. I know you're familiar with it, but a person who is justified in using reasonable force is immune from criminal or civil liability for damages. Criminal or civil liability for damages. I mean, it doesn't really say you're immune from criminal prosecution. It doesn't use those words, at least, that you'll concede. Why ought not we just look at the text and construe criminal or civil liability for damages to mean just that, damages including whatever might arise in a civil claim, or criminal restitution, but not criminal prosecution?
There's several reasons. First is the use of the word immunity. That immunity is, actually there's sort of two, but starting with immunity, the statute uses immunity, which has been interpreted in other contexts, in other statutes that this court's looked at, where there's been provided immunity from civil or criminal liability, and that's been held to require or allow for a pretrial determination that the point of immunity, in fact, the purpose of an immunity statute is to allow someone to avoid the hardship and cost and...
But couldn't we honor the text of the statute by reading that to mean there's immunity from a subsequent civil suit following a criminal case, which gets to the point of immunity from damages, which is what the statute says. It doesn't say immunity from criminal liability or criminal conviction.
I think to give effect to immunity from, it says criminal or civil liability. I think you've got to give effect to, the immunity applies to both the criminal liability and the civil liability. And so I think immunity, as it's been interpreted, requires or allows for the pretrial determination.
So many other state statutes use the term immunity from prosecution, and those are the states that held you have a right to a pretrial. Is it significant the Iowa legislature didn't use that term, immunity from prosecution?
It would be nice, of course. I mean, we can always stand here and second guess the language used, and certainly those out-of-state cases, most of them use the term prosecution, immunity from prosecution. However, as I've noted in, the Nelson v. Lindemann and Section 232.73, that used almost identical language, that a person shall have immunity from any liability, criminal or civil, and that was interpreted to mean immunity
Yeah, any liability,
pre-trial.
criminal or
And so-
civil, but, let me push back a little bit. It seems to me you're adding a word to the statute. It is immune from criminal, and you're adding prosecution. But it isn't there, criminal or civil liability for damages. I mean, why can't immunity be a limited concept? I mean, you're suggesting immunity necessarily includes criminal prosecution, but I don't know why that would be so. I mean, if the legislature wants to narrowly define immunity, consistent with constitutional restrictions, I guess it's free to do so.
I think immunity means before trial, but as well, we already had a justification defense in Chapter 704. There was already immunity, or not immunity, but Provision 707.6, which provided that someone shall not be civilly liable when they use justification, or when they're justified. And so there already were provisions just saying you're not going to be liable, and you have a right to come to trial and defend yourself on these grounds and be acquitted.
I have two questions for
Yeah.
you. I don't know if you can hear me. Can you hear me?
Yes, sorry.
This looks like a mic, maybe not. Okay, I have two questions for you. You said there are statutes. You just referred to 237.73. What other statute do you think is similar to how you're asking us to interpret this statute?
There's not much that's been interpreted. I mean, there's a lot of statutes out there that provide for, immunity from liability, but they haven't been interpreted.
Okay, well, I picked
Yeah.
up on the plural part when you said statutes, and
Yeah.
I saw 237.73, and I thought, do you know of another one? My second question is more to do, I think, with one of the state's arguments, was having that mini trial within a big trial would be a huge burden and expense. I don't remember for sure. There's 20 to 30 witnesses, perhaps, that happened at that trial?
That was, yeah.
And so to have that mini trial on an issue, it just kind of seems to me like perhaps the way the district court handled it did address those concerns after the fact. What are your thoughts on that?
This case, I think, is sort of the unicorn in a lot of ways. I mean, we have, in criminal procedure, there's several, there's a lot of options for having a pretrial hearing. You have motions to dismiss for, on statute of limitations grounds. You have motions to suppress, and those require evidentiary hearings. And I think often, just as often, this case, it was proposed there might be 20-some witnesses at a pretrial hearing. I don't think that's going to be the norm. I think this was an unusual situation with a large group of people. It was, in a public setting, so there were a lot of witnesses. But often as not, there's two people involved in this, and it's going to be a very quick determination. So I don't think,
But isn't that's, how could it be a quick determination? That mini trial, I think, would be the trial. I mean, they're gonna try and get that thing kicked out on immunity. So I don't see a defense attorney saying, I'm gonna take it light on that mini trial. I see that being no different than the actual trial.
yeah, I think that there's not always going to be 26 witnesses. I think often there's going to be a couple of witnesses. And
Well,
you know, and
let's
certainly you'll
assume there
fi-
was a case with only 5 witnesses. How would the pretrial proceeding that you're thinking of or conceiving of, how would that be different than a full-blown trial on the merits?
I think it's certainly an evidentiary hearing. I think it would be similar to a hearing on a motion to suppress, where sometimes those, you know, those are longer than the trial itself, as you've seen from records. So I think it's just an evidentiary hearing. The defendant has the burden of showing by preponderance that he was justified, and that the defendant can put it on in the way he sees fit. And sometimes that's going to require, you know, witnesses to come up and testify, and a longer protracted hearing, and sometimes it can be much more cut and dried, as we.
Is the jury verdict fatal to your defense?
I don't think so. We've argued that the procedure that the court ultimately relied on was fundamentally, resulted in a fundamentally unfair trial and an unfair hearing. And that's because Wilson was subjected to a trial where he had 2 fact finders. He had a burden of proof and he didn't have a burden of proof. The fact finders were answering different questions. And so the underlying trial was
So are you
unfair.
saying that, for example, what if we had one of these pretrial immunity hearings and the judge said, well, I've heard what has been presented at the pretrial immunity hearing, and I really I don't have enough to decide. I want to wait until after the trial. You're saying that's not permissible?
I don't think that would be, I think the judge needs to make a determination on the hearing that he's had, and then you go to trial. That would be a denial. I think if the judge says, I haven't heard enough, that means the defendant didn't meet his burden, and then you go to trial.
What about one other issue on the statute? It says that a person who is justified in using, who is justified in using reasonable force against an aggressor is immune from civil or criminal liability. What about the state's point that Khalik Jones, the person who was killed, was not an aggressor?
So there's a few things about that. First, that wasn't argued below. Everybody seemed to operate under the understanding that the 6 or 7 people were operating as a group and were acting in concert and together. So that was never, like, that wasn't a consideration raised anywhere below. That there was no jury instruction explaining that. There was no understanding from the judge when making that determination that you should be splitting out different people that were there. So first, I think that, and I think that's what the evidence showed, is that they were acting in concert. It was sort of a coordinated effort. And as well, what was my other argument on that?
Well, did anyone point a gun at him, at the defendant?
2 people drew weapons, and it's, one flashed it. It's not clear whether it was pointed at him. Another said he was turning and drawing, and that his testimony was that the defendant had already drawn his weapon at that point. But he said he saw 2 different, his statement indicated, Wilson's statement indicated he'd seen 2 different guns.
I'd like to direct your attention to your jury challenge briefly, and you have argued that the so-called Duran test should apply, and that you meet all 3 criteria of this test. One is that there was underrepresentation of racial minorities, and you say there was, and that it was a distinct racial minority being African American and Hispanics. But the 3rd criteria under Duran is systematic exclusion, that you have to have some evidence of systematic exclusion. And it seemed to me that the record here didn't show systematic exclusion. It showed statistical underrepresentation, and maybe you made prong 1 and prong 2 of Duran. But what about this 3rd prong? And the state raises this too.
And that's really what we've asked for, is a remand under Plain, under Lilly, and in more recent cases, that he didn't have a chance. He tried to get his evidence from the jury manager and wasn't able to get what he needed.
Now, was he diligent at that? I mean, the state kind of suggests, well, I mean, you knew the case was coming to trial, obviously, and in terms of prior jury pools, that information was available. The current jury pool obviously was only
Right.
made available, 10 days before trial or whenever. But does the record show diligent pursuit of the evidence, or does it show, I mean, on the one part of the spectrum, it could be sandbagging. On the other side, it could be just kind of lack of diligence. I mean, what's your argument for diligent pursuit?
You know, it's not entirely clear. It's about 12 days somewhere, before trial that the information was requested. They got the information they got just right before they filed the motion. And so, in plain, it looked like the jury information was requested the day of trial, and plain still found the defendant was entitled to this information and it needed to be remanded to allow the information to be had and the argument to be made. Thank you.
Ms. Nye, thank you as well. Mr. Slovan, you may present your argument on behalf of the state.
Thank you, Mr. Chief Justice. May it please the court. Counsel, good evening. It's a privilege to be here. I'm happy to explain what our position is that Section 704.13 does. But what's more important for this case, and frankly easier, is to explain what it doesn't do. It doesn't have the key language that's present in other states' stand your ground laws. It doesn't have the key language that's present in the other Iowa statutes that are mentioned in our Notice of Additional Authorities. It doesn't have the key language that's in the prior submitted draft legislation from previous sessions of the Iowa legislature that says immunity from criminal prosecution. That language is not in this statute at all. Instead, it provides a conditional immunity from liability based on a certain finding of fact that the defendant was justified in the use of reasonable force. So if we're going to give effect to the language that the legislature passed, I think the best way to do it is to do exactly what the district court did in this case. That is, hold a trial, instruct the jury on the issue of justification. If it's necessary, based on a challenge to the weight of the evidence or a motion for judgment of acquittal on the sufficiency of the evidence, then there's a potential to intervene and take the matter from the jury in that capacity. But this is an issue of fact for the jury to decide whether the defendant was justified, and the statute prescribes an effect of that finding.
What do you make of what I'll call the Lindemann line of cases? And very briefly, as I see Lindemann, I was a dissenter in Lindemann, I have to point out, but the thrust, part of the opinion was that, well, in order to give full force to an immunity provision, there should be a pretrial determination that one of the benefits that an immunity provision is designed to provide is to relieve a defendant of the costs of going to trial. Lindemann stands for that proposition, and then 1983 cases, federal civil rights cases tend to stand for that proposition. But you say, no, that proposition does not apply here. Explain why.
Part of the reason is that in the civil context, we have motions for summary judgment where we can resolve those fact issues on a record, a factual record that's built during the proceedings. We don't really have something analogous to that in a criminal case where we decide the actual disputed issue of liability.
But why can't we have a pretrial hearing just like a summary judgment hearing? I mean, we have pretrial hearings on motions to suppress, and sometimes the motion to suppress is the entire ballgame too, of course. Quite frequently it is. Why can't we have a pretrial hearing? It's got to be timely raised by the defense, of course, but why can't we have a pretrial hearing to give full measure of immunity, which includes not having to go through a potentially lengthy trial? Why can't we do that?
So I would say that would be fine if that's what the legislature authorized. I don't see any indication that that happened.
Well, except they use the term immunity. I mean, there's no express procedure, I agree with you, of course. But they did use the term immunity, and certainly in a number of contexts, immunity means relief from the wear and tear of trial. Why didn't they mean relief from the wear and tear of trial here?
Well, even in those contexts, though, it doesn't mean relief from the wear and tear of the procedure leading up to discovery and then to summary judgment, right? There's still wear and tear involved in the factual dispute on the way to the finding that immunity is predicated on these facts.
Well, sure. So the state could say, if a motion for immunity was filed, the state could say, well, we haven't finished discovery. We want to finish discovery before we have the hearing, and that would probably be granted. That'd be a reasonable request.
But we might not even have discovery in a criminal case if the defendant doesn't choose to take depositions.
Right, and if not, then the state has made its election, and it can present whatever evidence it wants to pre-trial. I mean, I'm not sure I see the problem.
We just don't have rules of procedure that would enable that to happen. We have specific procedural rules for motions to suppress and for motions to dismiss the indictment or information, but we also have a lot of case law saying that when you have a motion to dismiss an indictment or information, it's improper to have an evidentiary hearing as to whether the facts as alleged in the minutes and in the indictment information are true. And I think that, Mr. Chief Justice, your first question in this argument was, if it's immunity, if it's a real grant of immunity from prosecution, wouldn't it attach at the point of charging? And if I had to adopt a fallback position, I would say that's the one that makes the most sense. That if it really is immunity from prosecution in some regard, then the best way to read it is as an additional element of each charge where justification could be raised as a defense, that in order to approve an indictment or an information or at the preliminary hearing, you would have to find probable cause that the defendant wasn't justified. That's how it's interpreted in Kansas and I believe in Kentucky. The Kansas case is Ultreris. The Kentucky case would be Rogers versus Commonwealth. I think that makes the most sense if we're going to find any pretrial immunity at all in this. And the reason that makes the most sense is because it doesn't require us to make up a procedure for a pretrial hearing out of whole cloth. It leverages a competency that our courts already have, that our district court judges are already, they're already doing that inquiry, holding preliminary hearings, approving informations, and it also avoids all of the harms that we describe in our brief with having, I think it was 26 witnesses were on the defense list for the pretrial hearing that they wanted, and it avoids the pretrial publicity that comes along with that, where then it's going to be hard to get a jury panel of people who haven't heard about the findings on that standard ground hearing in that county.
Let me ask you, let me play out your theory. So your interpretation of 704.13 is that it's a jury determination, right? All right, well, let's take a counterfactual. Suppose in this case, Mr. Wilson had been acquitted, and then the family of Khalik Jones files a wrongful death action. And they say, well, that just means that he wasn't guilty beyond a reasonable doubt. Is it the state's position that case cannot be brought?
Under these facts, I think it would have to be. And it would be tough to say, usually you can't point to an acquittal and say, I know exactly what the jury found. In this case, justification was clearly the defense. There was an admission that he fired the shots caused the death. And I believe that the criminal rules at some point in the future may require a finding on an affirmative defense in special interrogatories submitted to the jury, which I think would be a smart way to implement that grant of immunity. Now, I want to point out that you previously asked the question that because Khalik Jones was not the aggressor, he was unarmed. And I believe there's an allegation that DeAndre Hicks was armed. That's disputed, and I don't tend to believe that. Certainly Xavier Hicks was not armed. There's a limitation in 704.13 that it only grants immunity from civil or criminal liability for damages incurred by the aggressor. So if you wanted to grant pretrial immunity of any sort on that language, you might grant immunity for a certain, you might grant immunity for murder in some situations, but attempted murder doesn't really inflict damage necessarily inherently on the victim. Intimidation with a dangerous weapon, you would find yourself granting immunity only on charges that have an element of damage to the victim/aggressor, and then going to trial on other charges that don't include that as an element of the crime. I just don't think that's a logical way to read this statute. I think that it only makes sense as a grant of immunity as a function of, that's a consequence of the fact finding that's engaged in at trial by the jury.
Well, what if, here we have some people armed, some not. Who's the aggressor if they're acting in concert? All of them?
Well, I think that if the jury acquits under, under this theory when presented with a justification defense, they find that the defendant is justified in that it's a reasonable use of force and the defendant's justified in doing it. And that, the same way that you might find transferred intent between somebody who he intended to kill and somebody who he subsequently did kill, you might find transferred intent between, and I think that it's a little trickier to interpret it, when there's collateral damage.
But Khalid Jones, he seemed like, according to the evidence, was a peacemaker in the whole thing. He was giving, there were two people hugging in the two groups, and he was one of the two people. He was a peacemaker. He's then shot in the back and killed. I'm just reading the statute. How is he an aggressor?
Well, he's not. I don't think he is an aggressor. Now, the jury could find that he is. In order to find, I think that it would be difficult to, and I guess that would go back to your earlier question of what would the effect be in a suit brought by the decedent's heirs and family and estate. And I think that there might be a factual issue at the open of that litigation about whether the decedent was the aggressor to trigger immunity, or that might just be subsumed within the issue of was the conduct wrongful, reckless or negligent or otherwise intentional or otherwise liable.
Isn't part of the problem maybe that 704.13 doesn't 100% dovetail with the rest of the provisions on justification? They don't all turn on this concept of aggressor, whereas 704.13 does.
Yeah, I think that's accurate, and I think that goes to the idea that this is looking forward from the litigation, from the criminal trial as to what happens afterward, and it's concerned with aggressors attempting to seek restitution or civil recovery for damage that they incurred as a result of their aggression, that might have been.
So what work do the words criminal liability for damages do in the statute? And if you imagine a world prior to this statute, if there's a finding of justification, under what circumstances would the defendant have criminal liability for damages?
So, and we try to describe this in our brief. The way I see it is, if there's a predicate crime that's committed, following that predicate crime and reasonably foreseeable as a result of it, there is a actual or threatened unlawful use of force against the person who committed that predicate crime, who is going to be the defendant. The defendant uses justified force in response to that unlawful use or threatened unlawful use of force, and the aggressor suffers damages as a result. Now, they may be justified in that use of force. The example we give is a felon in possession or a drug deal turned into a robbery, right? The predicate crime, it may be reasonably foreseeable that somebody will use unlawful force against the person engaged in that predicate crime or threaten the use of force. May be reasonably foreseeable that they're justified in responding with reasonable force.
That seems to be pretty far out. Isn't it just simply to say if he had a court-appointed counsel and he was acquitted, if he didn't have this statute, he'd be responsible for the attorney fees? Under our statute, that's what Dudley said. So there's a case where if he's acquitted and he had a court-appointed counsel, under this statute, he would not be liable to reimburse for the attorney fees, where without this statute, if he was acquitted, he'd have to reimburse for those attorney fees. And that makes perfect sense under this statute.
I think that makes sense. I think it might also do what I describe. And the reason I give that, and I know that we can go back and forth on Roach and Shears and the restitution cases. My point is that since there's an articulable theory of what this means, criminal liability for damages incurred, that an articulable theory of how it applies to restitution, that there's a purpose for the statute to end that speculation and say, under the theory that I'm describing, the justifiable use of force means no matter what the predicate crime is before it, even if the aggressor's damages were reasonably foreseeable within the scope of liability of that predicate crime, then that just cuts off the restitution liability there. I think that's a fine interpretation too. I think.
But doesn't the statute say damages incurred by the aggressor?
Right, and it wouldn't be. So I guess the attorney, you could characterize them as incurred, that the defendant would be liable for them, but the aggressor incurred them for the defendant. It's tricky. And I think that...
Would it just be easier to say this might be poor drafting? I mean, maybe this language isn't doing any work.
Well, and I know that we have a presumption against that. Sometimes and you can see that frustration coming through in the court's finding that this is void for vagueness, that it doesn't really know what to do with it. That's why I think it's easier to say what the statute doesn't do. If it was intended to provide pretrial immunity from prosecution, to create a brand new procedure that we follow pretrial, to add a whole new kind of pretrial litigation, it would have said so with some kind of something that gave more of an indication, rather than this language that looks like it's describing an effect of a finding that we have always entrusted juries to make about whether a use of force is reasonable and justifiable.
Do the House debate shed light on whether a pretrial evidentiary hearing was intended?
So we've gone back and forth on whether we should refer to those at all. The inspiration to do it is from the Doe 2017 expungement case, where they're brought up to about the meaning of what a single case number is. But in these debates,
I'm to blame for that.
I didn't want to. Anyway, so one representative says this will stop people like J. Rodney Lewis from sitting in jail before their trial and just waiting for their trial to prove their innocence. And another legislator says, no, we've talked about this, and nothing in this bill or any of those amendments would do that. Mr. Lewis would wait until trial to litigate his justification defense. And the first legislator says, you're right, I'm sorry, I was mistaken, you're correct. So I think that at the very least, this means that it's not unambiguous that it creates a pretrial immunity hearing. I tend to look at that as evidence that the people who were the most closely involved in drafting this litigation shared the understanding that we're advancing here. Thank you.
Mr. Slovan, thank you as well. Ms. Nye, you may present your rebuttal argument.
Thank you. Guess to start where we left off with the legislative debates, and I think we have the same problem that that's the statements of two people, and that's not the entire legislature and what they intended. But I also
they're not just two people.
Right.
There's Representative Wolf, whose amendment this was, and Representative Winchell, whose bill this was. So why isn't that entitled to some significance?
Well, to the extent it is, I think that the characterization that Representative Winchell starts by saying this, this constituent of mine was stuck in jail, and this would prevent that. Representative Wolf denied that. She said this was my amendment, but first it was part of her amendment. She had a different draft, a complete overhaul of 704 that evidently this was plucked out of and put into 517. So what it might have meant in her bill with whatever other revisions she had is different than what it might mean getting plugged in here, where it is adding a new provision that seems to be different from the justification that's already in 704. So we have that even her understanding may not apply when it's put in a different context. But also, when he backpedals, I think he's backpedaling because on the factual circumstances of that case, and that involved two witnesses who were lying. And I think it comes out that, even if you'd had this hearing, you'd had some sort of pretrial hearing, if those two witnesses came in and lied, your guy's not getting off pretrial. And so my read on it was that had to do with the specific circumstances of that case that he was advocating for. But again, this is that was a 3-hour debate. We could debate a lot of it.
What do you make of the argument that there's no procedure outlined in the statute? You heard the suggestion that, well, for summary judgment in civil cases, we have rules that well-known, published. We don't have rules in the rules of criminal procedure for resolution of pretrial immunities. The statute clearly has no procedures in it. Why isn't that the end of the road for you?
Just because, first of all, this is the problem that other states have addressed when they've had it, and they've had no guidance in the states that have had no guidance. Some statutes lay out a procedure, and
And I would say that's actually part of it in Kentucky and Kansas, is that they provide for different procedures. But the other states that just say you're immune from prosecution, and I recognize they use the word prosecution, but you start with Colorado, and I've cited several in my briefs that they've started from scratch, and they've said, well, this has to mean something, and so this is the best procedure we think that makes sense. And the fact that there's no rules for how to do this is because this hasn't existed before, and there will be rules if depending on the decision of this court, of course. So I don't think it's that hard to imagine that rules will be enacted, or we have motions to dismiss. Again, I've said evidentiary hearings are routine. Pretrial evidentiary hearings happen frequently in the district court, and I don't think it's that difficult to expect the court to, I think a court can manage that. Let's see. I think the other problem with the interpretation that the damages only applies to money damages or restitution, to the extent that it only applies to damages, that again, how does it play into civil liability for damages? Because there's already a provision saying you're not going to be civilly liable for harm incurred, pursuant to the use of reason. 707.6 already provides that if you're not going to be liable civilly, you're not going to be paying damages. And so if we interpret damages to only mean money damages, then it renders that the civil piece of 704.13 redundant and without effect. But I think also damages is sort of, damages is the way we legally quantify the harm or the loss to a victim or to a person. And so I don't think it has to be that complicated to interpret damages to mean loss or harm. Like, that's what it is. But this is how we, put a legal quantification on that harm. So for the reasons argued in my brief and today, we'd ask that you reverse his convictions and remand for a new trial and a new hearing on the immunity. Thank you.
Ms. Nye, thank you as well. The case of State of Iowa versus Lamar Wilson is now then submitted to the court for a decision. Before adjourning our court session tonight, however, let me just make a few comments. And the first are simply directed to you with our gratitude for your attendance tonight. We understand that you could be doing a lot of things with your night, but you chose to spend it with us, and we are very appreciative that you did that, and we commend you for that. The courts play a very, very important role in society, but too often our courts are not very visible to society. We do so much of our work outside of public view. And so 8 years ago or so, we decided it was important for our court to leave Des Moines and go into the communities across Iowa so that you could see the way we do our work and maybe gain a better understanding of how we do our work and what our role is in our important government. We function very differently than other components of government, but I think in a way that is very contemplative, very serious, and gives ultimate strength to our democracy. Tonight, what you've seen is the last public hearing in this case, State versus Wilson. We will now, over the coming weeks and months, retire to further study this case, research the issues, and ultimately write a decision that will speak to an outcome of all of the issues presented in this case. And then that outcome is put into our legal history and becomes part of our law that will guide all of us in this state into the future. And this is the culmination of the process of the way the law works and affects our lives. And again, thank you very much for being a part of it. As I said, there will be a decision. It'll be months from now, but if you're interested in following it or following any decision of the Iowa Supreme Court, you can go online and we file our opinions every Friday, and every Thursday of each week we identify which case will be filed on the following Friday. So you can follow along with this case and all others. We also look forward to joining you in a reception that it will immediately follow this proceeding in the Commons, the big M Commons. And we are thankful as well for the cookies and the fruit trays that will be provided by the MCC Culinary Arts Career Academy. Thank you again. With that, I would ask the bailiff to adjourn court.